The Matric Results publication decision is now being challenged in court by the organization AfriForum. The Basic Education Department says it will not oppose the application. It earlier instructed media houses not to publish Matric results. The matter will be heard at the High Court in Pretoria tomorrow. Matric results are expected to be released on Thursday. Well, let's discuss this with Ahmore Burger-Smidt from the firm Werksmans Attorneys. Thank you, Ahmore, for your time this morning here on eNCA. So the department, upon making the decision, said it was trying to fulfill the objectives and objects of the Protection of Personal Information Act, citing Section 14 there, and basically saying that this is personal information of pupils who have written the matric exam and shouldn't be shared in this manner. Were they even on the right track? Because I'm puzzled by the fact that they're not even going to defend that decision in court. Do you believe that they were even on the right track to start off with?
You know what? I do not believe they were completely on the right track. And what we see here and what we're experiencing is an absolute but utter misinterpretation of the Protection of Personal Information Act, the POPIA Act. The POPIA Act does not prohibit in itself the publication of the matric results. And the first statement that was issued stated that it's based on POPIA that the results can't be published, and POPIA prohibits the publication. At the same time, earlier this morning in the media, it was reported that this matter that will be heard on an urgent basis tomorrow is stating that the information does not constitute personal information. Now, both those statements are completely and utterly incorrect.
Sure. Expand a little bit more, because now you've got me intrigued when you say that information, the matric results, the interpretation that says it doesn't constitute personal information is as incorrect as the reliance on POPIA by the department to not publish the results in the traditional manner.
So let's start on the issue of whether it constitutes personal information. We need to be reminded that since 2014, the matric results are published reflecting the student's or learner's exam number and ID number. Both those things constitute personal information. In fact, the exam number constitutes a unique identifier of the learner that the Department of Education assigns to the learner, in terms of which the learner will be identified. And there can be no debate that an ID number constitutes personal information as well. So in itself, it constitutes personal information. And that's a basic concept underlining the whole debate that we're currently having. It constitutes personal information. Now we need to enter the next stage of the debate and the analysis around this, whether it can be published, the information, the personal information. If we look at the rest of the world, and our POPIA legislation says, you know, we can take into consideration what the rest of the world says. And in the rest of the world, in terms of the EU legislation, the GDPR, and if we look at the UK, all those legislation provisions stipulate that the information, there's no prohibition on the publication of the information. What is, however, very important, and we refer to it in POPIA as the openness principle, is to what extent do we make parents and learners aware of the fact whether we will be publishing information. And if I talk about no prohibition on the publication of the exam results, I'm talking about those learners above 18%. Consent is not required for the publication of that information. And if we look at the EU specifically, it clearly says that schools have got a legitimate interest in publishing this information. So we need to unpack the reasons and the rationale a bit more. If learners are below the age of 18, the POPIA legislation says you cannot process the information. In other words, you can't publish the information without the consent of a guardian or parent. So if the matriculants are below 17, yes, consent is necessary. But above 18, the debate is not one of consent. The debate is far more involved in the analysis required. And yes, the statement that it doesn't constitute personal information is wrong.
So if we take from where you left off, should there be a tweak of some kind then in terms of how the department goes about in publishing this information? One, the notification and letting everyone know that this information is personal information, it will be published, but also addressing that whole issue of consent for under 18s, because I imagine that would be the bulk of the pupils completing matric.
Well, it won't necessarily be the bulk, because one would assume the bulk of matriculants are now above the age of 18 by the time the results are published. But the below 18s consent is necessary, yes, and the department will need a process and procedure for that. And the department will also require a way to communicate how this process will work. You know, in trying to explore this and trying to find whether there's a public interest or whether the legislation, what the legislation prescribes, the legislation dealing with the schools and the processes dealing with the personal information, and together with that, you know, the gazettes guiding how one would deal with this information, it is very clear that the exam results of public schools, the Department of Basic Education holds that information, and they can decide themselves how that information will be published. And this is what we've said here. They're ignoring the public interest and just putting a blank no publication. And there is a general expectancy in terms of the public interest for the information to be published. So if we look at research purposes or even individuals having access to the information, we know clearly that if we consider, you know, the National Schools Act together with the regulations pertaining to that, you know, this information can be published. What is required from a data privacy and a POPIA perspective is the necessary policies, procedures, and processes, and the openness of communication to let every learner know that his information will be published. And just as important, allow for the learner, the data subject, to object, to say, but I do not want my information to be published. That process must be made provision for.
Makes perfect sense. Lastly then, Ahmore, before I let you go, you mentioned the whole issue of in the public interest or general public interest. Why is the publishing of this information, you know, legitimately in the public interest? Have you been able to wrap your head around what purpose it serves?
Well, if we look at the regulations issued in terms of the South African Schools Act, it specifically refers to issues around research, for instance, as an example. You know, the ability to conduct research, to evaluate the results, and for individuals then to have access to this information, or non-governmental institutions. Now, in one fell swoop, that access to the information will not be allowed. And if we talk about it from a public interest perspective, researching and analyzing the matric results ought to be in the public interest from a research perspective.
I agree, I accept that. It's the media publication part of it, not the processing of the information, as in it's information the department holds. And generally, I would accept the proposition that for research purposes, yes, it can be processed in that manner. I'm not sure if I'm convinced what purpose the publication on a newspaper serves when the same department will give me my results when I go to the school.
Well, can we just analyze that a bit? A number of students have gone home. They're not at the school they used to attend. So it's not that easy to just knock on the school's door to obtain the results. So how will the learner now access his or her results? And if we talk about the concept of legitimate interest, in the South African legislation, the POPIA legislation, there's a legitimate interest of a data subject, the learner, as well as the schools or the government Department of Education, or then third parties. And leaning on international precedent that and examples that we've got to avail and to learn from, it's clearly been stated in the EU that there is a legitimate interest for the information to publish, and if we work to be published, and if we work this back to the learner now living or at home, you know, 350 kilometers from the school, surely it is in his legitimate interest to have this information published in a forum where he can easily gain access to it.
I agree, Ahmore, but there are other platforms that I'm told they now use. For instance, they can send an SMS to a number that you've provided. But I'm completely out of time, and I suppose it's a subject that we can pick up at a later point. I've got to thank you for sharing your insights into the subject with me this morning. By the way, I love the view from your office.
Thank you very much.
Ahmore Burger-Smidt from the law firm Werksmans Attorneys there, talking to us from her office with the skyline of Sandton there in the backdrop.